Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I am joined by my co-host and the managing partner of our firm, Nicole Bikakis. Today what we are going to discuss is how the courts in Connecticut handle contribution to college for children in divorce, custody, and child support cases. But before we get into that, Nicole, how's your week going so far?
Going well. We took a long weekend and went down to Richmond, Virginia to visit family down there, and it was really nice.
Nice. What'd you get any golf for Tommy? How old's Tommy? 5?
He's 5.
He's a big golfer.
Big golfer. Yeah, he got to play golf a couple days with his dad and his uncle, so that was, I think, the highlight for him.
How many holes does he play at a time? Do you know?
I heard that I think they were playing 9 holes, and I think by hole 5 or 6, he may have been hanging out in the cart watching some cartoons.
Real? Tommy was? I thought he was just like addicted to golf, and that would take
he's
precedent
5,
over
and it's
cartoons.
really hot in Richmond.
Yeah, that's true.
He did pretty good, though, I heard. He was really into it.
Nice.
I don't know.
Nice.
I don't know. Could I last 9 holes? I don't know.
Yeah. I woke up. I'm in the midst of newborn. My daughter's. I have a 2-week-old and a 2-year-old, and my 2-year-old was sort of like running around. She woke up early while I was still trying to sleep, and my wife Jess is still trying to sleep, but she was up, and I eventually woke up, and my glasses were gone. I couldn't find my glasses. So I was like, rarely do I get mad at Isla, my 2-year-old, but I was pissed. I wasn't like acting pissed towards her, but I'm just like fuming inside of Isla, like lost my glasses. Like that's the one thing that like you don't touch daddy's glasses. And yeah, I was just like looking. She was really bearing the brunt internally for me of my anger. And I'm looking everywhere, and then eventually I found them behind my bed, and I'm pretty sure I dropped them back there. So yeah.
Well, I'm sure the exhaustion doesn't help with your general temper.
Yeah. I think there's still a piece of me that's like trying to blame it on Isla that it was her fault and she put them back there. But I think if I'm being honest with myself, I'm probably the person who put them there.
Isla can do no wrong.
Yeah.
In my eyes.
Usually that's the case, unless my glasses are missing, then she gets the blame, whether it's her fault or not. Anyway, so let's talk about contribution to college in divorce and custody cases. So a lot of people think it's just divorce cases where the courts can order contribution to college, and that is not the case. It can be custody cases where the parties were never married, or just child support cases. Sometimes people will just pursue a child support order without dealing with custody. And in that situation, the court can also order contribution to college. So generally how it works, for the court to be able to issue orders for the parents to contribute to college, the first hurdle they have to reach is that they have to find that had the family remained intact, it is more likely than not that the parents would have contributed towards college for the children. So if the court cannot make that finding, then they cannot enter a educational support order at all. And as far as contribution to college, it's only undergraduate tuition, or tuition, room and board, which we'll talk about later. But this applies to undergraduate or vocational school. It does not apply to graduate school.
And it only applies through the child turning 23.
Right, exactly. It's capped at 23. If your kid's 30 and decides to go back to college, you're not going to get a contribution. And it's also capped at 4 full years. If your child goes to school, takes 5 years to get their undergraduate degree, then the court cannot issue orders for that 5th year. And it is also capped at the cost equivalent of the University of Connecticut. So and it's 4 years of the University of Connecticut. It doesn't matter where your child goes to school. Your kid could go to Yale, for example, which costs way more money. But the maximum that the court can order the parents to pay is the cost equivalent of 4 years of UConn's tuition, books, room and board, food, etc. They'll look at all of those costs, and they will cap it at that. Now that cap can be waived by the parents if the parents agree at the time of divorce that they want to not have that cap and they want to be able to pay more towards college. That is possible, but absent agreement from the parents, the most that the court can order is that cost equivalent of UConn. And it's not the cost at the time of the divorce, it's the cost at the time the child is going to school. So let's talk about timing on how this kind of happens logistically. So a lot of times when you're getting divorced or you are entering into a custody agreement or custody orders, your kids are young. They might be 5 or even 10 or even 16, at which time you have no idea where your kid's going to be going to school, what your financial circumstances are going to be when they do go to school. You have no idea what any of this stuff is going to be, what the cost of UConn is going to be at that time. So in almost all situations, unless your kids are closer to, graduating or you have significant financial resources, in almost all situations, you will say that the court will retain jurisdiction over post-secondary educational support. And when it comes time for your kids to go to college, you'll do your best to try to work out an agreement with your spouse. But if you can't, then at that time, either one of you can bring the other one back to court for the court to issue orders about who is going to pay for how much of college and what that's going to look like.
And what's really important is that, especially as part of a divorce proceeding, if your child isn't in the midst of applying to colleges and this isn't a current issue because your child is younger, you have to reserve the right to seek educational support from the court as part of your divorce agreement. Or if it's not part of the divorce agreement, the judge at trial during your divorce will make a finding. If the two of you had remained an intact family, you would have, to the best of your ability, provided support for your child's college education, and they will order that jurisdiction reserved by the court. So in the future, if a dispute does arise between you and your co-parent as to what the cost college should be or how you each will contribute to that cost to cover that cost, then you each have the right to use the court to help you settle that dispute.
Right. And if you are having a trial, it's very important to know in advance of that trial if you have an agreement that, had you remained an intact family, it's more likely than not that you would have contributed to college. You want to know that in advance if you want to have the court retain that jurisdiction, because if you don't have an agreement and say your spouse is of the opinion that he or she does not want the court to retain jurisdiction, then it's important that you present evidence of the fact that it is more likely than not that the two of you would have contributed to your kids' college if you had remained an intact family. And as far as what you would want to present as evidence, the biggest one is like the existence of a 529 account or CHED account. If you have that account, it's pretty obvious that you intended to contribute to college, because why would you have that account if you didn't? But you will also want to present evidence of conversations that you and your spouse had with one another about plans to contribute to your kids' college, or conversations that you and your spouse had towards, with your child or children about the fact that you planned to contribute to college. So you want to make sure you present that evidence if you don't have an agreement.
I mean, the big one is the existence of savings earmarked for college, and whether that's a 529 account or some other savings account that was earmarked for college. the existence of that type of an account is going to lead the court to find that you would have, to the best of your ability, contributed to your kids' college education, which allows the court from there to move on to determining what the allocation of responsibility should be.
Right. And some families, they decide that they don't want to pay for their kids' college. Everybody's values are different. Maybe, you paid for, your own education and you think that sort of, you want to instill the value of sufficiency on your child. And your way of doing that is that they pay for their own college. That's totally fine. And in many situations, you and your spouse may just agree at the time of your divorce or, your custody orders going into place. You may agree that you do not want the court to retain jurisdiction over post-secondary educational support, and, your kids will, just pay for their own school, or maybe you will pay later, but you won't have, the court will not be able to come in and say that you have to pay for college. So if you and your spouse are on the same page about not paying for your kids' college, the court can't make you pay for your kids' college. And this statute also doesn't give your children the right to, they don't have the ability to bring a claim against the parents. This is only one parent being able to bring a claim against the other, trying to get them to contribute to college. There's no right for the children to sue their parents to get a contribution to college.
The statute does not entitle the child to seek contribution to their college expenses from their parents. It's there to allow the parents to share in the responsibility if they've decided they want to help their kid with paying for college. And sort of back to your point, in today's era, especially, paying for college it's a privilege, and a lot of families can't afford it. And so it's not a foregone conclusion or an inherent right that kids have that their parents are going to help them pay for college. And importantly, too, a lot of kids want to go to these very expensive schools. And of course, Connecticut has that cap that you discussed, that a court would only be able to order up to the cost of in-state tuition at UConn. But the idea that just because one parent even wants to contribute, if the other parent does not, then a court isn't it's now a foregone conclusion that there will be contribution if one parent doesn't want to. But it's certainly if both parents are of the same mind that they're not going to help the child pay for college because they can't afford to, or for the reasons Matt laid out, that they don't think that will instill the right values in their child, then the child definitely does not have a right to seek from the court any contribution from the parents.
Right. And just because the court retains jurisdiction over post-secondary educational support, that also does not necessarily mean there is going to be a order for contribution to college. There could be a scenario where you say, my kids are 5 and 2. I have no idea what the deal is going to be. So let's have the court retain jurisdiction and we can figure it out later. And then come time for your kids to go to school, you don't have any money or you have very little money. The courts are not necessarily going to order a contribution to college. They might say you don't have the
factors that, we'll go over, but they look at your financial circumstances and what ability you have to afford any such contributions.
Right. And we'll cover that in a little while. So other sort of hurdles that you have to get over in order to get a court to enter orders for contribution. So again, the first one is getting the court to even retain jurisdiction. But then when it comes time for your kids to go to school, both parents have to be involved in the decision making about where the child is going to school. The statute requires it. You can't just, let's say dad hasn't talked to the child in 5 years or a year or whatever, or for whatever reason you don't involve dad in the discussion at all. You can't just say, Dad, you have to contribute to college now. The statute requires the parents to discuss and agree upon where the child is going to go to school, if there's going to be a contribution to that school. And if they cannot reach an agreement about what school they are going to contribute to, then either parent needs to file a motion with the court, basically telling the court, hey, we don't agree on the school. We need the court to issue a decision about the child's school. The court doesn't have jurisdiction to like decide where the kid's going to go to school, but they can decide the appropriate school for the parents to make a contribution towards, if that makes sense.
Basically, the decision as to what school a child goes to is the child's decision, right? What we're talking about is the cost to attend college. And like you said, this needs to be a joint decision, or at least there needs to be involvement and opportunity to be heard and to be involved in that decision-making process. Now, everyone might not agree on which school is best. And if the disagreements are coming down really to the cost, that's the piece that the court is going to weigh in on in terms of what should each parent's contribution be based on their involvement, where they wanted the kid to go to school, their financial circumstances, the kid's abilities, and all these things. So, and something else to keep in mind too is, as Matt was saying, one parent can't unilaterally make the decision if a parent hasn't been involved and then they don't seek to involve them or give them any information. But on the flip side, if one parent just refuses to be involved or does not respond to any of the information that's being provided to them, and they don't take any efforts to involve themselves or educate themselves on the different options that of the schools that their child's applying to, or to talk to their kid, they're not going to be able to then say that, well, I wasn't involved, so I'm not going to pay anything. The court
Right, but that's in that situation, the involved parent needs to file a motion with the court to basically say like, hey, I tried to involve my ex-spouse. They are not getting involved. I need the court to issue an order saying, this school is okay, because the statute requires them to communicate with one another and agree. And if they cannot agree, then either parent can file a motion with the court. So you need to file a motion in order to really cover yourself to prevent the situation of the other parent saying, hey, I wasn't involved in this. I can't now be compelled to contribute to school. So some other things that need to be fulfilled for the parent to be able to be compelled to contribute to school are that the child must maintain at least a half of a full-time course load. They have to stay in good academic standing with the school, and they also have to make the academic records available to the parents. So they have to, show the parents their grades. The court's not gonna order contribution to college if the kid's just like not gonna tell them anything about how they're doing in school or things like that.
Right. So, if you want your parents to pay, you also have to then be willing to share your report card with them.
Right. Exactly. Even though you're an adult, if you're getting your school paid for, I like that, the report card. So now let's talk about kind of real world, how this works and what the likelihood is of a judge actually ordering a contribution to college. So like many other things in divorce, but probably especially in this area, the results are very unpredictable as far as what a judge is going to do with regard to ordering contribution to college. Judges are sort of like all over the map on their own values about what they think a parent's obligations are to pay for their kid's school. Some judges are, maybe more old school and feel, college kids are adults and it's their own problem. If the parents don't agree, no parent should be compelled to pay for their kids' college. Maybe they paid for their own college when they were putting themselves through school. So some judges are of that opinion, and other judges,
maybe the cost to go to school when they went to school likely a little less than it is
Yeah.
today.
Yeah, it's like insane, and it's scary, frankly, like the fact that a kid, sure, they're technically adults, but a kid who's 18 is like making a decision that could put themselves in hundreds of thousands of dollars worth of debt that is non-dischargeable in bankruptcy. Like, it's scary. I don't think a kid's brain is developed enough to make that kind of decision, to really understand the implications of that, crippling debt. And but that's sort of a separate issue. But it is scary, the cost of college and what kids get
I mean, when you
themselves
look
into.
at, the release of like what a lot of colleges are charging these days, there's so many colleges now. It's like $70,000 a year
Oh,
to attend college.
more than that. I mean, I think there's plenty of schools that are into the 80s and 90s. It's crazy.
It is scary, and I think what your point is really well received, that this is such a massive financial decision that's going to impact them. And even if parents can contribute, likelihood is they're not going to be able to cover the whole amount. And again, Connecticut does have that in-state cap, which I think right now is around 38,000, or if I'm not mistaken, is the in-state cost of tuition for UConn with room and board and all of that. So again, these kids really are undertaking these very expensive degrees, and which has also opened up a whole other conversation that people are having, is whether a college degree is worth it in today's age, and if it is even a wise decision for kids to go to college, given the jobs that exist when they come out.
Right. And
Going
that's something that judges are going to look at. They're going to look at the individual kid and say, like, all right, this is a kid who's not really taking school seriously. Like, maybe there's evidence that they don't want to go to school, or they're just, some kids just are not meant to go to college. Maybe vocational school would be better for them. And that's something that the judge will take into consideration, is the child's kind of preparation and readiness for
aptitude. Yep.
right, for school.
And
There
also,
are
like,
also
what is their major that they're trying to major into? They might look at that as well, because it's one thing to, go to a school that costs a fortune, and you're studying something that there might be a return on investment. But, for others, some judges will make this. I guess, to your point, is judges are all over the map on this. Some judges might take into account what their study, their chosen major is, and how that's going to prepare them to, financially be able to cover the cost of all these things. And others, won't. Other judges won't care what the major is. Particularly, it's just kid gets to go to college, and they get to choose what their major is going to be and what their school is going to be. And we have a cap that we're willing to order parents to contribute up to.
right, and they're going to look at the child's grades in high school, how they did in high school. There's some of these schools where it's like anybody can get into it, and it costs $70,000. Like, God knows what they're gonna, do after they graduate if they don't do well at that school. So that is a factor that the court is going to consider. But the biggest one is just the financial resources of the parents.
And also, though, did the child try to apply to any scholarships or take advantage of any opportunities to get financial assistance? That's going to really also factor in. So when you're in the process of bringing this motion to the court, and you're now having a hearing on who should pay what for college, if you have evidence that there was opportunities for the child to seek certain financial assistance or scholarships, and they made no effort to enable themselves to get additional assistance, that will also factor into the judge's decision making.
Right. Or if they actually do have access to financial resources, then the court will also take that into consideration when determining the parent's contribution. Maybe the kid, has a trust from like grandparents or something like that. Or, most kids don't have assets other than that, but they, if they do have scholarships or could have received scholarships, that will be taken into consideration by a judge. But the biggest one is just going to be the financial resources of the parents. They're going to look at, the income, assets, and debts of their parents, and sort of decide, are these, can these parents afford to put their kids through school? And again, that's really sort of where it's very unpredictable. Some judges,
It's
you take that,
subjective. Whether
right?
someone thinks a person can afford something or not is somewhat subjective. Some judges might feel that, especially parents are typically well into their careers at that point. Maybe they're nearing retirement, depending on what they have in retirement or savings. And if they're still earning an income, are they retired or are they still earning an income? Like all these things are going to be factored in, given that at the time that your child is now looking to go to college and and you're being asked to contribute. And we've seen judges take the outstanding costs or take the that cap and kind of just divide it into three and say one responsibility is mom's, one responsibility is dad, and one responsibility is the child thinking that the children need to have skin in the game and they need to be also contributing to the cost of their own college, and it can't just be on the parents. But some judges feel like no, the parents should be the ones covering the cost. So it varies.
Yeah, and it's tough. I mean, parents, you probably on the one hand, want to contribute towards your kids' education, but sometimes you just can't afford it. And I know people who are 65 years old, would be getting close to retirement age, and they've got like $200,000 of debt, because they paid for their kids' education, and they don't have any assets, and it can be a really difficult decision to make, and it's just tough. Like, some judges will say like, no, I'm not going to order contribution to college because these people, they need to prepare for their own retirement. They can't work forever. Like, how are they going to pay for this school? They need to be thinking about themselves. And other judges, what you'll sometimes see is like, all right, dad's been paying child support for 15 years. He's not going to be paying child support anymore. Let's put that, those weekly payments, put those towards college. So sometimes you see judges do that, but it's really all over the map. And sometimes you will see the court issue orders, at the time of divorce, if they still don't know where the kids are going to go to college. If parents have a lot of money, then they may just say, all right, you're each contributing 50% to college, or you have to put this money aside into a 529 account, and that money goes towards your kids' college if they go to college, and if they don't, they get the money when they turn 30 or some age. So yeah, it can be tough to sort of figure out what the right thing is to do as far as paying for college for kids versus preserving assets for retirement. And it's the fact that it is such a difficult decision which makes the results so unpredictable. Judges, again, they're all over the map on what they do in these types of cases. So, with that in mind, as we say in all of our videos, if you can find a way to reach an agreement with your spouse or ex-spouse about who's going to pay for how much of college, it's best to do that rather than having some judge make a decision when you really don't know what they are going to decide.
Right, because we've gone into hearings and judges have declined completely to issue any orders for contribution to college expenses. We've gone into hearings where we thought this person's financial affidavit is showing they have all this debt. They don't have a particularly high income. They have high expenses. And the judge still finds that, well, we can find some room in here for you to be able to contribute something to your kids' college expenses. So it really varies. And if you can be reasonable with your co-parent and come up with some fair apportionment of these costs so that you guys are willing to cover, and in conversations also with your kid, your kid understands like this is what's available for us to assist you with in paying for college. And typically where this comes to the court is more often than not, there is the child that's sort of closer to one parent or more aligned with one parent in terms of paying for college or where they want to go. And then the other parent disagrees. And so again, a court's going to be looking at, was that other parent involved in that decision? And then, from there, there are no guarantees as to what that level, because again, there's a cap of in-state tuition at UConn. It doesn't mean the court's going to order that cap. The court's going to look at whatever the costs are, each parent's financial circumstances and ability to afford contributions, and then make a decision.
Right. So let's talk about timing of sort of bringing an action if you can't reach an agreement with your spouse. So pretty much you want to be thinking about this and dealing with this as soon as your kid decides where he or she are going to go to school. Or again, you need to involve your ex-spouse in the decision making about the school, the school that the two of you are going to contribute to. So you want to be figuring that out as soon as possible. And if you can't reach an agreement, file a motion with the court as soon as possible, because you don't, the court in Connecticut, it's slow. I mean, there's other states that are slower, but it's slower than you think it is. So if you file an action, your first court date might be a month or two later. And then if you don't reach an agreement, your hearing is a couple of months after that. So you don't want to be filing a motion for court, a motion for this a month before your kid's going to go to school or a month before tuition is due. By that time, it's, I don't want to say it's too late, because, maybe you confront the money and the court will figure it out later. But you want to be getting ahead of this as soon as possible, because, I've seen situations where, people file too late and, child, they can't pay for, they literally can't make the first payment, and they get, they can't register for classes, things like that. They can't even go, they miss their first semester. You don't want to be in that situation. So filing as soon as possible is very important, so that a judge can be making a decision in a timely manner, and you're not putting your kid in a difficult spot where they don't know what's going on. And what kid wants to go into, their first year of college, which is a big, it's a big life moment, not knowing how it's going to be paid for, who's going to be paying, do I need to take out student loan? It's just, you need to be thinking about this as soon as possible and filing something with the court as soon as possible.
Right, because the kids are going to be having deadlines by which to accept the position or accept, and then also doing their financial aid applications. Like, they have to make sure that they're timely in submitting their documents and responses. And so they need to know what exists in terms of funds for them to afford the choice that they're going with. And so as from the moment the child starts thinking of schools, and you get the information as to what is the cost of all these schools, and you have most of the information you need to kind of understand how much money is going to be needed for the child to attend the college that they want to attend, or the different choices that they have. At that point, you need to assess, is there a disagreement? Are we going to be able to work this out between ourselves? And if we're not, let's get that motion filed. Or even if you have an inkling that there's going to be a disagreement and a dispute over who's paying what, get it filed with the court.
And then the last point I want to make is, if the circumstances change after that initial order has been put into place, you can seek a new order. So let's say, you agreed that you're each going to pay 50% of that UConn cap, and then you lose your job and you can't afford it anymore. You can file a motion asking that the court change that order to reduce your obligation. Another thing to note is that the court does not necessarily need to issue an equal contribution from both parents. So let's say, the parents were divorced 15 years ago, and since then, one of the parents has really struggled financially, and the other's, done great financially and has millions of dollars in assets. In that situation, the court may order the more financially well-off parent to contribute 100% of that Yukon cap and the other parent to contribute nothing, or, some other percentage. The fact that the court is entering orders, it does not have to be an equal contribution from both parents. But back to what I was saying, if the circumstances change after that initial order was entered, you can seek an order. So let's say there was a job loss, you lose your job, you want a different contribution ordered. Or let's say, the court ordered no contribution, and then you found out, after your kid's freshman year of college, you find out your ex-spouse's parent died and they inherited a ton of money. Maybe in that situation, you go back to court and say, hey, circumstances have changed. My ex now has a lot of money and really can afford to contribute to our child's school. Just keep in mind, if an order is entered, that is not set in stone. That can be changed down the road.
Also, if your child starts college and likes to party and decides that they're not going to really attend class and things kind of start going downhill and they have a really low GPA, then that also would be a basis to go back and have the order changed.
Right. You can go back and say, hey, judge, the statute requires that my child remain in academic good standing in order for me to be obligated to pay, and they aren't. So therefore, I shouldn't have to pay anymore. And hopefully you would put into an agreement or a court order, if the judge is making a decision, hopefully they would put in something that says, you are obligated to pay so long as my child remains in good standing, so that you don't have to go back to court and seek a modification if your child, gets put on academic probation or something like that, has multiple semesters that are not good. Hopefully that would be automatic, but, you can seek to get a new order if the circumstances change. So those are the basics on how the court handles contribution towards education, post-secondary education. That's what they call it. Most of us think of it as college, but the court calls it post-secondary education. That's how the court handles that in divorce, custody, and child support cases here in Connecticut. Nicole, do you have any final wise words that you want to share with everybody?
Just that for some people, it's really tempting at the time of their divorce to try and they don't want to deal with this issue. And sometimes they say, you know what, let's waive it. Let's not even leave it open so that we don't have to deal with this in the future. But, I always counsel people against waiving the court's right to step in and retain jurisdiction over this issue and assist with any dispute that might arise later. When you're waiving the right or waiving the court's jurisdiction to enter orders under the statute, and your kid's 5 or 10, and then all of a sudden they, years later, your kid's not going to college and you feel differently than you did at the time of divorce, you've waived that jurisdiction. The court cannot help you. So just always err on the side of retaining that jurisdiction. And then the hope is that neither of you will need to come back to court to utilize the court services and determining and figuring out who's paying for what. Hopefully you will together as parents be able to come to an agreement and work things out together with your child and all be involved in that decision. But if you can't, having access to the court to assist you in making that decision, and also frankly making the other parent come to the table and offer to pay something to avoid the judge's order, that's really important. And so I just counsel people against being tempted to just waive the court's jurisdiction at the time of the divorce.
That's good advice. So that's going to do it for this week's episode of the Irretrievable Breakdown podcast, where we discuss all things divorce. As usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well. It's Dolan Divorce Lawyers here in Connecticut. Thanks for watching, and we will see you next week.